So watching Joy News today, I am Daniel Daze. Let's take you back to the Accra High Court, where our correspondent Joseph Akable is speaking to some of the lawyers involved in that landmark ruling.
What you are saying, is it your contention that if that document had been made available to you, it could have boosted that defense that he put up?
Call it exculpatory evidence. Exculpatory is favorable evidence. Anything. Because see, the thing about law, the thing about criminal prosecution is that an accused person need not even say anything at all. An accused person can stand mute of the court. And it's the duty of the prosecutor to prove their case beyond reasonable doubt. An accused person can just sit and stare, and that's about it. And therefore, if at the end of the day the prosecution is unable to prove its case, it inures to the benefit of an accused person without opening his or her mouth. In the instant case, it's not as simple as that. It's a case where the prosecution specifically and deliberately, there's a lot of evidence on the record. And indeed, the prosecution was specifically accused, not only by one witness, but about 2 or 3 witnesses, of deliberately hiding evidence from the court. And the evidence is quite clear. The issue is, if the prosecutor has a good case, why withhold evidence from the court? It's the duty of the prosecutor to put before the court. An accused person doesn't have that burden in law.
On the sentencing, the court had some reservations that when you conferred with your client didn't express any desire to refund the money. I mean, the court had clearly held that he should have refunded the money.
That was unfair in my view. You notice that when it comes to sentencing, it's a different ball game. The judge herself had indicated that, I mean, elsewhere, time is given to people, but only she was not willing to adjourn proceedings. You cannot ask a lawyer to confer with a client in the glare of the court in 5 minutes and expect us to come up with anything reasonable.
At least you could have settled on the figure that the state says it has come to him.
It's even deeper than that. The real point of the matter is that if you're not satisfied with the judgment, there's a danger that you will compromise that judgment by making certain concessions to the court. Because if you're not satisfied, you've got a right of appeal. But if you move beyond that and make reparations, as good as admitting the conviction, and that may impair your ability to appeal against it subsequently. So what we did was tactical.
So you can confirm to us that you'll be filing for that appeal?
Listen carefully. I mean, obviously, I've got instruction. We're going to do that. Other places, they've got what they call plea bargaining. Okay, a plea bargaining is essentially a situation in which the prosecution and the defense can agree, negotiate that, okay, if we bring in such amount, you will not get this kind of sentencing and so forth and so on. But in the situation that we found ourselves, even if we decided that we're going to, I'm talking about the accused persons, they will even go to refund the entire amount, the judge will still go ahead and sentence them. So what benefits that to me? If indeed I'm accused of having stolen your money and I give you that money, you still have the right to sentence me for a term that I do not know. Nobody's going to do that.
So how soon can we expect you to file that appeal? You've already said you filed it.
Please, I'm acting on my client's instructions, but to the very best of what I know, based on what we have discussed. I need time next week, the appeal will come out. And I can also assure you that it will be coupled with an application for bail pending the determination of the substantive appeal. That much I can tell you. I can assure you that based on the discussions that I have, don't forget that I'm only a lawyer. We always act on instructions, and therefore what I'm telling you is what has transpired between me as a lawyer and my client. And I'm telling you on authority that based on the instructions that I've received after the sentencing, we've been empowered or ordered or directed or instructed to file an appeal. And the appeal will be against the conviction.
Thank you very much, Lawyer Kweku Pencil. You heard Lawyer Kweku Pencil there. He's lawyer for Philip Assibit, the first accused person who has been handed a jail term of 12 years. I'm standing just right in front of the law court complex. And the big one, if you are just joining us now, and if you've not been following this story keenly, Daniel, the big one now is that a lawyer for Philip Assibit has served notice of filing appeal against the conviction handed in by the Accra High Court. And for those who may still be not privy to some of the details that have come up, Daniel, the issue of mitigation did come up, and the concern of the judge had been to the effect that, I mean, she had expected that Mr. Assibit, who in this case was the beneficiary of the 3.3 million cedis, would have at least informed the state of his desire to refund that amount of money. And you heard me try to put that question to the lawyer as to why they didn't go for it and inform the state of their desire to refund that amount of money. Yet we are told that, I mean, they asked and deferred to the court to enable the court decide. where I'm standing currently, this is just the main entrance of the courtroom. Now, when those two individuals were coming into the courtroom this morning, they were led into this entrance. That is how come they entered the court premises. The difference this time around when you are leaving the courtroom is that once the court finds you guilty and you're into the courtroom, the handcuff is placed on your wrist, and this time around you are not led out of this exit. It's a different exit that is used. There's a jail waiting room where you are led into from where you are led home. I can tell you that the two individuals right after the sentence were handed, the two individuals had the handcuffs placed on their wrist and were led out of the courtroom there. So this is the latest coming from the Accra High Court Financial Division, to be specific, is that former Gyeeda boss Abuga Pele and businessman Philip Assibit were both accused financial law, respectively, have been handed 12 and 6-year sentence. Daniel.
Thank you very much, Joseph Akable, for that latest in from the Accra High Court, delivering that new update that the counsel for Messrs. Philip Assibit and Abuga Pele will be appealing the case and applying for bail, so they do not have to go to prison. You're still watching Joy News today. Let's take sports now with Benedict Ozu.